Hi guys, I'm Gauri and I'm a legal intern at Lexis and Company. Today's video is about legislative power regarding elections. The major articles that will be covered in today's video are Article 170 Clause 3, Article 71 Clause 3, Article 82, Article 324, Article 327 and Article 328. So let's start. The manner and by which authority, how each state can be divided into territorial provisions for election of Lok Sabha and state legislative assembly are mentioned under Article 82 and Article 170 Clause 3 of the Indian Constitution. Also, any matter that is related to the election of the president and vice president can be regulated by the parliament. This is mentioned under Article 71 Clause 3. All right. The Parliament may make provisions by law subject to the provisions of the Constitution with respect to matters number one relating to and number two or in connection with the elections of either house of the Parliament, that is the Lok Sabha or the Rajya Sabha, or to the state legislative assemblies. It can include 1. Preparation of electoral rolls, number 2. Delimitation of constituencies, and all the other matters necessary for securing the due constitution of several houses. This provision is mentioned under Article 327 of the Indian Constitution and it is enforced under entry number 72, list 1, that is the Union list. Also, the supreme power is vested in legislature, but the power subject to provisions of the Constitution. It cannot go beyond the limits prescribed under the Constitution of India. Similar law is with respect to the states is mentioned under Article 328 and this provision is enforced under entry number 37, list 2, that is the state list. Now, there are various acts that need to be studied with respect to legislation. Number one is the Delimitation Commission Act 1952. It provides Delimitation Commission making which will make adjustments of seats in and division of territorial constituencies for election to Lok Sabha and House of Central Government. All right, and House of State Legislative Assembly. And the commission has to be appointed by the central government. It should consist of three members, two sitting or retired judges of the High Court or the Supreme Court, and Chief Election Commissioner, that is an ex officio member. All right. And yes, for all the people who do not know ex officio and the people who know ex officio, the people who know ex officio, please mention it in the comment box down. And the people who do not know ex officio, I'll be writing the answer of the meaning of ex officio in the comment section. So please check the comment section. The final order, which is binding, cannot be called in question by any court. Once the commission has take a decision or uh, it is binding and cannot be questioned by any court. The second is Representation of the People's Act 1950. There are two Representation of People's Act. One is 1950, one is 1951. The 1951, it provides for the qualifications of voters of such elections and the preparation of electoral rolls. And the 1951 Representation of the People Act, what does it provide for? It provides for the actual conduct of elections to the Houses of Parliament and to the state legislatures, qualifications and disqualifications of memberships of those houses, and the corrupt and illegal practices and other election offences and the decision of election disputes. This act, the Act of 1951, is self contained and to ascertain the true position in regard to any manner connected with elections, the rules and the act need to be looked upon. This means that this is a very important act. And this thing was provided under the Punnuswamy case. The fourth act that we are going to study is Presidential and Vice Presidential Elections Act 1952, and it comprises of matters relating to the elections to the offices of the President and the Vice President. All right. One important case that we have here is Lakshmi Charan Sen versus A.K.M. Hussain. Okay, what it provided us was that directions issued by the Election Commission to the electoral officers are binding upon such officers. But they have a force of law to create rights and liabilities between the contestants of election. And in the absence of statute, directions issued by the EC cannot be equated with law. Remember one thing, elections are a statutory right, like we studied in one of the previous videos. Elections is a statutory right, it means that it has limitations imposed by a statute. So, if there is no statute, how can we equate the directions that are issued by EC to the law? It cannot be done, right? So, it cannot be done. And EC can take steps or direct the steps that can be taken over and above those which it is obligated to take under law, that are the election officers. And directions are binding but not to be treated as law. I'm stating this once again, directions binding but cannot be treated as law. Okay, one another case that we have is Kanhaiya Prasad Sinha versus Union of India. This was the Patna High Court judgment, and it said that directions issued by the Election Commission under Article 324 may be directory or mandatory in nature, but even then they cannot be ignored. All right, this is it. And so, just a quick recap as to what we did today. Uh, To start with, we did 5 articles of the Indian Constitution: Article 71, Clause 3, Article 82, Article 170, Clause 3, Article 324, Article 327, and Article 328. And what do they say? That Election Commission's directions are binding upon election officers, but they cannot be treated as law in absence of statute. I hope this video was helpful to you all. If you have any recommendations, please let me know in the comment section down. And please like, share, and subscribe if you like this video. And yes, many more videos to come. Also, if you have any question regarding anything or where I missed anything, do let me know in the comment section and I will answer to it as soon as possible. Thank you.